Good afternoon, everyone, and welcome to this month's roundtable with the Legal Studies Cluster at Nickel and Dimed. We will be discussing the Digital Protection and Digital Personal Data Protection Bill of 2022. And to kickstart the discussion, we'll just talk about jurisprudence on privacy as a right and the history of the DPDP Bill 2022. So, Ishita, why don't you get us started?
Sure. So firstly, I'll talk about the jurisprudence of the privacy is a right. Now, right to privacy of an individual means the right to be let alone and the right of a person to be free from any unwarranted or any unsolicited interference. Now, there are a few landmark cases that need to be discussed while looking at the right to privacy. Firstly, I would like to point out two landmark cases, MP Sharma case and the Kharak Singh versus State of Uttar Pradesh. In MP Sharma, the landmark case, it's known for having rejected the argument that the right to privacy should be considered under Article 21 of the Constitution as a fundamental right. Similarly, in Kharak Singh versus the state of Uttar Pradesh, the Supreme Court held that the right to privacy should not be a fundamental right, and it did not come under the ambit of Article 21 of the Constitution. Um, However, um, in the nine bench landmark case of K.S. Puttaswamy versus the Union of India, the court held that the right to privacy it's an invaluable asset of Article 21 of the Indian Constitution. The court in this case, they specifically overruled MP Sharma and Kharak Singh insofar as these two cases expressly did not recognize the right to privacy as a fundamental right. Now, it can be discussed that the Indian jurisprudence with regards to the right to privacy has evolved so far, and that the decision to put the right to privacy under the ambit of Article 21 was a very much needed step, especially after the COVID pandemic, wherein we live in a hugely technological era. The right to privacy is a very essential component of the right to life, and it has to be given that much respect after the Puttaswamy judgment has specifically pointed out that the right to privacy has many facets, and therefore, in every condition possible, like matrimonial or political or commercial, the right to privacy of a person should be respected and it should be taken care of. Now, at some point, there have been numerous arguments stating that because the right to privacy is not a fundamental right, there are restrictions on the same and that they must be subjected to restrictions by the state. But here is where all the debate lies. For instance, in the case of Aadhaar, where the government said that the data was being taken in state interest, the argument on the other hand was on the inquiry of the data as to for what purpose was the data being used. Not only in India, judges in other states as well have linked the right to privacy as one of the essential aspects of human beings. And slowly and gradually, we can observe that in India, the right to privacy has been developed. Like we can see this by the virtue of the fact if we compare how far India has come from cases like MP Sharma and Kharak Singh to the case of Puttaswamy. Now, I will move on to discussing the DPD bill, which is the Digital Personal Data Protection Bill 2022. India's Ministry of Electronics and Information Technology, they recently released the draft of Data Personal Data Protection Bill on November 18, 2022. Now, the bill constitutes the latest series of draft legislation propagated by the ministry in the Indian Parliament as well as for the public consultation over the last few years, which is since mid 2018, in a bid to introduce a comprehensive data protection regime in India. Now, remarkably, the DPDP bill has been introduced just a few months after the Ministry of Electronics and Information Technology announced the withdrawal of its predecessor, the Personal Data Protection Bill 2019, which was the PDP bill, in August 2022, after the Joint Parliamentary Committee reviewed the PDP bill and proposed over 80 amendments and multiple recommendations. Now, the new and streamlined DPDP DPDP bill intends to provide for the processing of digital personal data in a manner that recognizes both the rights of individuals to protect their personal data and the need to process personal data for lawful purposes and for matters connected therewith or incidental. Now, now, India has strengthened the data protection regime. Um, Again, I'm going to reiterate the K.S. Swami versus Union of India case, wherein Justice K.S. Swami unanimously, the nine bench of the Supreme Court in this case, they unanimously held that Indians have a constitutionally protected fundamental right to privacy under the Article 21 of the Indian Constitution. Similarly, the BN Sri Krishna Committee in 2017, wherein the government appointed a committee of experts for data protection under the chairmanship of Justice B.N. Sri Krishna in August 2017, that submitted its report in July 2018 with a draft protection bill. Now, this report had a wide range of recommendations to strengthen privacy law in India, including restrictions on processing and collection of data, data protection authority, right to be forgotten, data localization, etc. Additionally, information technology intermediary guidelines and data and digital media ethics code rules of 2021 were also passed, which mandated social media platforms to exercise greater diligence with respect to the content on their platforms. Lastly, this bill recognizes the data principles right to post-mortem privacy, which is withdraw consent, which was missing from the PDP bill 2019 but had been recommended by the Joint Parliamentary Committee, which is the JPC.
Okay, thank you so much, Ishita, for giving us that overview to get us started on this discussion. So the next question that we'll be focusing on is the data protection laws around the world. What would be some of the areas that we think should be reconsidered in the newly drafted bill? I'll take up that question. So the DPDP Bill 2022 applies to all processing of personal data that is carried out digitally. This would include both personal data collected online and personal data collected offline but is digitized for processing. In effect, by being completely inapplicable to data processed manually, this provides for a somewhat lower degree of protection as the earlier drafts only excluded data processed manually specifically by small entities and not generally. Furthermore, as far as the territorial application of the law is concerned, the bill covers processing of personal data which is collected by data fiduciaries within the territory of India, which is processed to offer goods and services within India. The current phrasing inadvertently seems to exclude data processing by Indian data fiduciaries that collect and process personal data outside of India, of data principals who are not located in India essentially. This would impact statutory protections available for clients of Indian startups operating overseas, thereby impacting their competitiveness. This position further seems to be emphasized with the DPDP Bill 2022 exempting application of most of its protections to personal data processing of non-residents of India by data fiduciaries in India. Moreover, the current draft removes explicit reference to certain data protection principles such as collection limitation. This would allow a data fiduciary to collect any personal data consented to by the data principal, making collection solely contingent on consent, ignoring the fact that data principals often do not have the requisite know-how of what kind of personal data is relevant for a particular purpose. For example, a photo filter app may process data related to your location or information on your contacts, even though it may not require such information to carry on its primary task of applying the filter. It does away with the concept of sensitive personal data. Depending on the increased potential of harm that can result from unlawful processing of certain categories of personal data, most data protection legislations classify these categories as sensitive personal data. Illustratively, this includes biometric data, health data, genetic data, etc. This personal data is afforded a higher degree of protection in terms of requiring explicit consent before processing and mandatory data protection impact assessments. By doing away with this distinction, the DPDP Bill 2022 does away with these additional protections. Additionally, the bill also reduces the information that a data fiduciary is required to provide to the data principal. While the previous iterations required considerable information in terms of the rights of the data principal, grievance redressal mechanisms, retention period of information, source of information collected, etc., to be provided to the data principal, the current draft reduces the scope of this information to the personal data sought to be collected and the purpose of the processing of the data. While this may have been done in an attempt to simplify the notice and avoid information overload, there are other ways such as infographics, just-in-time notices, etc., that are being recommended by data protection authorities to ensure a comprehensive yet comprehensible notice. Moreover, the DPDP bill seems to suppose that a notice is only to be provided to take consent of the data principal. There is a limited understanding of the purpose of a notice herein. A notice is also important for the data principal to exercise the data protection rights as the right to know what personal data is being processed by whom, whether the data needs correction or updation, also to request deletion of data that may not be relevant for the purpose of processing. These rights exist even in cases of non consent based processing of data. As such, limiting notice to only consent based personal data processing would limit the scope of the exercise of these basic rights. So, one of the things we see is that a lot of things have been removed from this DPDP bill in comparison to the earlier three data privacy laws that had actually come in. So, there's a lot of scope for addition to this very data protection law. That takes me to the next question, which I request Arushi to take up. How important is it for India to have a data protection law?
Yes, thank you, Misha. So, tech law is not really my place of knowledge. So, if I go wrong in any of my observations, please correct me. So, I have narrowed down the question and focused on why we need to have this particular bill become a law. So, the DPDP bill of 2022, why do we need this particular one as opposed to a general overview of data protection laws? So, I'll just begin with some statistics. So there were as many as 6,258 cyber complaints that were received in 2021 as compared to 2,914 in 2019. So there's been a clearly an increase in the number of cybercrime, the rates in cybercrime in India. And cybercrime against women especially has increased by roughly 15%. So in the light of these new cases, and in the light of the developing sector of health tech, a data protection law is extremely important to have in a country that protects not only protects your data but allows the consumer to actually take up recourse in the court in case their privacy is invasion. So, so firstly, I've highlighted some points regarding the existing IT Act of 2000 that we have, which, as opposed to the new DPDP bill, which defines and segregates information into categories. So it defines sensitive or personal data, which is extremely important, which the IT Act does not do. The IT Act, instead of defining, it just goes on to a few sections that states the punishment in case any tech company violates your privacy rights, but it does not describe sensitive or personal data in general. So this DPTV bill describes and segregates information into three categories, and one of the most important one being sensitive or personal data. So another important aspect of the DPTP bill is that it provides localization of data, or that is storing in India of data. So it views data as a national asset. So another important point of the DPTP bill is that it facilitates data ownership. By bringing in data principal and data fiduciary, it allows the person who's providing the data to own their own data, which is extremely important. So as I mentioned, in the rising industry of health tech, it requires serious legal surveillance because with the rising industry of health tech, the information that we're putting out is extremely sensitive in nature. And it also is important because we do not know how much of the information is going where. So the DPDP bill requires digital companies to obtain explicit permission from a user, that is the data principal or the data owner, before collecting their personal data and requires in the notice to state what are they going to be using it for and who are they going to be sharing it with, which is extremely important because as it was noticed in previous cases. For example, Facebook was receiving data of users, but we did not know where it was going and to whom it was being shared and how it was being used. So this is an extremely important point that the DPDP brings up, because of which we need to have localized data personal laws in India. So it also brings about India's commitment under the international law, which Article 12 of the Universal Declaration of Human Rights and Article 17 of the International Covenant on Civil and Political Rights states that the protection of human rights is referred to human rights instrument, and the latter makes it mandatory for states to take up steps to realize such rights. So India has a commitment under international law in order to protect privacy as a fundamental right. And hence, under this, it is important to bring up a data protection law that protects privacy as a fundamental right. Yeah, thank you.
Great. I'll just add on one more point. So, given that we've entered into an era of surveillance capitalism, which basically is a market-driven process where the commodity for sale is your personal data, and the capture and production of this data relies on mass surveillance of the internet. I think that makes having stringent rules and regulations in place to protect your data even more important, because companies like search engines like Facebook, like Google, and social media platforms like Facebook collect your personal data and then share it further with companies requiring such data. So it's like a continuous economy that's in that's it's a new model of economic production, which is making the concept of data protection even more important in today's day and age. With that, I'll go on to the next question. So, do you think that data protection bill can or cannot be adapted to meet the privacy needs of emerging technology? Gayatri, why don't you take that question? Oh, sorry, Arushi, you had something to say before we go on to the
Yeah,
next.
sorry. Yeah, sorry, I forgot to mention the particular fact. Like when you brought about the data surveillance capitalism, also the practice of personalized advertisement that is increasing in today's times is also another reason because of which we need to bring in data protection laws. So yeah, just a small point.
Yeah, I think that's quite pertinent. Gayatri, why don't you take up the question about whether this data protection bill can be adapted to meet the privacy needs in this emerging technology era?
Okay, so it's necessary that we begin by acknowledging that there are a lot of things in this particular data privacy bill that itself fails to meet the requirements that are set by, say, GDPR and other privacy legislations across the world, right? So, which is why it's already lagging behind when it comes to the kind of technology that we have at the moment, and it lags behind on four main points. One being your consent, the other being your data localization and cross-border transfer, the third being what are the requirements for this sort of data localization and cross-border transfers. And also, most importantly, the fact that they have something called the government exception, which gives vast power for the government to continue surveilling its citizens, collect that data, process it the way they want without any consent requirements established, right? And these 4 points are necessary to understand how, at the moment, the new DPDP bill is not ready even for the present technology, let alone for the ones that are going to come ahead. So the fact that we have a facial recognition technology on the rise and that it's being used mostly by your state agencies to surveil their citizens and for a variety of reasons, right from curbing of crime to even profiling of people for political gains, etc. So it's necessary that we have specific consent established. And the moment now, the DPTP bill, the way it is structured, says that you have a consent at the beginning of the step, right? You get consent from your data principal for a wide range of activities at the beginning itself, and then continue processing the data for a long period of time. Whereas if you look at the other legislations that we have, say, suppose GDPR in the in European Union, it requires that you take consent of the data principal at every step of the way, right? so you have to have very specific goals established as to what you're going to process your data for. And the minute you have a change in that plan, perhaps you are not using it for that initial purpose that you mentioned to the data principal, then you again notify the data principal saying you would like to process the data for so and so purpose. Or it could be such that there are a few more steps added on the way and you would want to continue using the data. So again, you ask the data principal for a specific consent. So it's very stringent in the sense that the data principal is at all steps of the way informed as to where their data is going for what it is being processed. However, the way the DPTP bill is at the moment framed, it requires the consent of the data principal at the beginning, but what happens later is completely unknown to them. And the fact that we know that given even now when we have data privacy policies at different apps or websites that have, there's like this really long document which data principals don't really spend all that time reading it. And, and over here, another interesting thing to note is that, for example, when you look at GDPR, it has a specific requirement that whatever policy notices that we give, be it for consent or where you're disclosing your privacy policies, the language of such policies should be easy to understand, very clear and to the point, right? This is a specific requirement under GDPR. However, we don't see something like that under DPTP. So the fact that we have a nation where almost 50% of a population does not have digital literacy. And when you bring in a data protection bill of this kind, it is necessary that you also have a provision that allows the data principal to be informed throughout the process of the data processing, and also that there be a requirement that whatever consent is obtained, whatever notices are shared with the data principal are in such a language that they understand it, right? And it's very important that that happens. Now, moving on to the second thing about data localization and transfer. So the way that DPTP at the moment works is that where the data is transferred and how is come all comes down to the decision of the central government. They decide which countries can have access to your data, how it goes ahead, and all. So essentially, the power is localized in the hands of the government, central government at that, which basically uh, is against the principles of that are established under say scrims 2. So there are like a series of cases, basically three cases that took place in European Union, where they established the principles which now form the bedrock of many other data privacy policies across the globe, especially the case called shrims 2. I might be pronouncing it wrong. It's SCHREMS, shrims 2, in which essentially in this particular case the European Court of Justice struck down the data privacy policy that EU and US had on the grounds that it did not have requisite safeguards in place for a transatlantic data flow, and that it did not have compatibility with the EU laws. And in this, the important points they mentioned was that how it needs to be in consonance with the other data privacy policies around the globe, and how there should be some safeguards so that it stops the other countries' intelligence and security agencies from accessing your country citizens' data. So right now, we don't have any of those safeguards under DPTP, right? And the fact that the government itself, our own government itself, has such wide powers as to what it wants to do with our data, where it goes, etc., this basically puts a huge dent in DPTP, because the whole idea of data privacy should be your data being protected from all sorts of institutions, not just private but also government, given that the government also has um, vast amount of our data, personal data, especially sensitive data. And this is where even Puttaswamy judgment is not really of much help, given that even though the judgment recognizes a right to privacy being a fundamental right, it also states that the government, in the interest of public or larger public interest, can have access to our data, such as our biometrics, our Aadhaar numbers, etc. All the data that we have currently under Aadhaar, all of that should be accessible to the government at all times of the time, and it is completely valid, right? So this main point remains unaddressed even in DPP. And also, furthermore, it is important to note that when it comes to DPTP, it puts the threshold of minority at 18 years, which is definitely not in line with the way data principles at the moment um, the demography of the data principals at the moment, because a large majority of the data principals who are at the internet and online at the moment, a large majority of them are teenagers below the age of 18. So this is another thing that is not in line with the other data privacy policy that we have in other countries such as EU and US, and also the fact that given the technology that is being developed and available in the market, a lot of it is for teenagers and minors. So we need to also give all these rights that we have: the right to consent, the right to withdraw your data, the right to um, um, get the processed data. All of the rights that are there right now in DPTP should be something that is accessible even to minors, given that they are also a major stakeholder in this process. So which is why, because of these points, at the moment DPTP is not prepared for the kind of technology we have at the moment. If they are rectified, it can be compatible to the needs that we have, given the technology advancements that have arrived at the moment and also are expected to be around in a few years.
Thank you, Gayatri. I think that was extremely comprehensive in the form of an answer, and that'll take me to our last question. Essentially, walking the tightrope between national security versus data privacy versus the needs for business. So, how do you really tackle this dilemma? Shreya, why don't you take that?
So yeah, before we talk about privacy and security, we need to focus on what's the difference between privacy and security. So privacy is about keeping our own information to ourselves. So it privacy does not necessarily guarantee us protection from people who are trying to sneak in or trying to get access to our data. It's just a way to protect whatever information we have, like sort of say like not allow people or create a barrier. On the other hand, security is more of a true defense against data breaches and people trying to get access to our data. So when we talk about privacy, our bigger focus should be on data security for people who are at the risk of having the data be dissipated to sources which they do not want. And then when we come to national security and its relationship with our privacy. So the data protection rights do not need to completely disregard the idea of national security. Obviously, that has to be something that should be kept in mind. But then there are what can be done is that in our acts, certain exceptions could be created, and these exceptions could be but these exceptions should also be very limited and precise. Like for instance, the United Kingdom's Data Protection Act of 2018, the national security is an exemption in that act, but it does not entirely goes like it's the exemption does not extend to the entire act. And it requires a certificate that has to be signed by a minister of the crown, and this also can be challenged by the person who has been affected by like the tribunal. So the idea is that even if we are allowing people to or the government to have access to our data, there has to be certain procedure, and even if there are exceptions, they cannot go across the act. They have to be very specified and limited. And as Gayatri also mentioned, that certain registration should be there or certain certificates should be taken. That is a very good way to go about it. And then in India, although there are even though there are reasons for providing the exemption, this requirement has yet to be tabled in the parliament. And in fact, the order which invokes the exemption is not a gazette notification that provide the exemption. So basically, our even if we are trying to get that exemption wala part, it's not something that has been talked about in the parliament or has not been passed by the Gazette of India. So then that also impacts us a lot. Now, if I talk about the Aadhaar case, because that in that case also, Justice Chandrachud has his own dissenting opinion, and this dissent also gives us a greater idea into the impact of this sort of the importance of data privacy and how we should look at it. So he also mentioned that something which he due to which he felt that the Aadhaar Act was not exactly constitutional was because he said that the Aadhaar Act was introduced in the parliament as a money bill. So it being introduced as a money bill goes against whatever are the notions of the Indian Constitution regarding our own privacy, security, etc. So in addition to that, he also further laid down that the Lok Sabha speaker should have allowed the Aadhaar Act, which was introduced as a money bill, to at least go through proper judicial review before it even got passed. So that's what was his opinion, and yeah, that's my take on it.
Thank you so much for that, Shreya. So I think from our discussion today, we were able to clearly state that the DPDP bill of 2022 has a lot to work on. There are a lot of things that need to be added and addressed. And that said, I think it like the three previous data protection bills before this, there's a lot to do. In the case of data protection in India, there's a lot that needs to be added, a lot it needs to be clarified, and yet again we are left with the dilemma of how much there can be in a particular act, especially something that is so complicated that not too many people even understand. And we're again left with something, we left with only questions and not really an answer to the solution of data protection and data privacy in India. But with that, we come to a close for this month's roundtable. Thank you for joining in, and we hope to see you next month. Thank you.